I'm Kristen Osenga, a professor at the University of Richmond School of Law, and I'm going to give you a quick recap of the Supreme Court's decision in Apple v. Pepper. If you want an app for your iPhone, you have to get it from the Apple App Store, and that means Apple has a monopoly on the market for the apps. Because Apple has a monopoly, a group of consumers sued under antitrust law, alleging that Apple was using this monopoly power to charge unfairly high prices. Now, Apple doesn't make most of these apps, and that's where the legal issue in this case comes in. Instead, developers create the apps, and then they sell them through the App Store. Although the developers set their own prices for the apps, consumers purchase them from the App Store. Then Apple keeps 30% of the price paid by the consumer and gives the other 70% of the purchase price to the developer. The plaintiff's argument is that because there are no other app stores available, consumers end up paying more for their iPhone apps than they would have if there had been a competitive market for apps. That is, if there's multiple app stores, Apple may not have been able to charge this 30% fee, and developers would not have passed that fee on to the consumers. The problem in this lawsuit is an old antitrust case called Illinois Brick that holds only direct purchasers can sue a monopolist for antitrust violations, while indirect purchasers cannot. Apple argued that the plaintiffs in this case, the consumers, are not direct purchasers from Apple, but instead are purchasing the apps from the developers, because the developers set the prices. So the district court agreed with Apple and said the case could not go forward under Illinois Brick. But the Ninth Circuit reversed, finding that the consumers did directly purchase from the alleged monopolist Apple. So the whole issue before the Supreme Court in Apple v. Pepper is who can sue under antitrust law. On May 13th, the Supreme Court, in a 5-4 decision, agreed with the Ninth Circuit and held that the consumers who purchased the apps from Apple were indeed direct purchasers from the monopolist and could sue under Illinois Brick. The majority, authored by Justice Kavanaugh, said it was a really straightforward conclusion, and that consumers in this case were not multiple steps or layers away from the monopolist, as was the case in Illinois Brick. Rather, there's no steps at all between the consumers and Apple. Consumers paid the allegedly uncompetitive fee straight to Apple. Apple's argument that it didn't set the prices for the apps, so therefore it wasn't the seller, did not sway the court. And according to the opinion, Apple's argument doesn't make a lot of sense, other than as a way to gerrymander Apple out of this and other lawsuits. Justice Gorsuch authored the dissent, focusing on proximate cause. Specifically, the dissent contended that consumers did buy apps from the app developers at prices set by the app developers. The 30% fee charged by Apple, if it is unfair, is actually borne by the developers, not the consumers, unless the developers pass that fee along to the consumers in their pricing. That multiple-step argument that requires the uncompetitive pricing to be passed through is, according to the dissent, the exact point of Illinois Brick's prohibition on suits by indirect purchasers. So now the consumer's case can go forward on the merits, and it's back to the district court to determine whether that 30% price is anti-competitive. And that's Apple v. Pepper.